We are here for the oral argument in case 19CA011593. Sajid Mullaji versus Waheeda Mollagee. Ms. Mollagee is the appellant in this case, so Mr. Gottfried, you would be starting this matter. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do wish to reserve time before you begin your argument, let me know how much. I will mark that down. I'll do my best to track time for you and try to keep you apprised of how much time you have left. These arguments are being visually and audibly recorded. They're streaming live now and will also be posted online later. We have read your briefs, and I know there is a child at issue in this matter. Please do not use the name of the child. All right, we are ready to begin when you are.
Thank you very much, Your Honor. Can the court hear me?
I can. Can everybody hear? Okay.
Yes.
Thank you. Your Honor, I would ask to reserve 3 minutes for rebuttal.
Okay.
Thank you. Your Honor, as the court knows, my name is Gary Gottfried. Myself and Douglas Brill represented the appellant in this case. We have filed in our brief, our merit brief, and have addressed a number of issues. Because of the limited amount of time, we're not going to address each and every one of those issues. I know the court's read the briefs, but I do want to address what we consider some of the core issues in this case. I think that the first issue is, did the court have subject matter jurisdiction to hear and grant a divorce when we believe the parties were not married? That brings us to an essential difference between the approach which we have taken and the approach which the appellee has taken with regards to the standard of review. We believe that the standard of review, is a de novo standard of review. The appellee in his brief argues that the standard of review is an abuse of discretion. We believe that it is a de novo review because it requires this court to make a determination of the law based upon the facts versus a purely factual determination, which would be in part a abuse of discretion. We believe that a number of courts, including this court in a related case, has found that in this particular situation, the standard of review is de novo. We've cited the Lee versus Melanson case out of the 11th district, the McKettrick case out of the 12th, and the Tatson case of the 10th. Interestingly, the appellee in this case filed a supplemental list of authorities. And one of those authorities was a case called In Re CW out of the 9th district. And in that particular case, although it dealt with the juvenile court looking at its authority, this court said that the standard of review was in fact a de novo standard of review when a court looks at the determination as to its subject matter jurisdiction. So we believe that in the first instance, this court looks at this case with a de novo view versus abuse of discretion. Assuming that the court finds that this is a case where it should look at the case with a standard of a de novo review, I think we can agree on one fact. By that, I mean the parties both agree, appellant and appellee, that the parties only participated in a Muslim religious ceremony. The evidence in this case is very clear. No one, I believe, disputes, although I will allow counsel to address that issue himself, but I believe that no one will dispute that there never was a civil marriage as that is defined by South African law. Now, although we agree that these parties only participated in a Muslim rites ceremony, I think we disagree on what the effect of that religious ceremony is. We believe that when we filed our motion to dismiss, that The evidence in this case before Judge Boros on our 12B1 established that, in fact, a Muslim religious ceremony does not create a civil marriage under South African law. Both parties had witnesses, expert witnesses testify. We had a gentleman by the name of Abbas, counsel for the appellee, had an attorney by the name of Julian. Both parties agreed on a couple of things. Number one, both agreed that there were some inroads being made in South Africa with regards to people who enter into these religious ceremonies. But what is important for this argument is to point out to this court that both experts agreed that a Muslim rite ceremony does not create a valid civil marriage under South African law, and that appears in the transcript, volume 1 on page 88. Both experts agreed to that. Now, what's also interesting is that at the hearing before Judge Boros in November 2016, the appellee also admitted that all he participated in was this religious ceremony. He never took the position that there was some civil marriage that had existed. So the evidence was clear. There was only this Muslim rite ceremony. Now, the appellee, both at trial and in their brief, argues that under South African law, a religious marriage is given what they call legal effect. I am not going to disagree that in some instances, the testimony was that under South African law, parties who participate in a religious ceremony do have certain rights. I don't disagree with that. The evidence was clear. A person who participates in a religious ceremony has the right to seek child support. A person who participates in a religious ceremony has the right to request what we would call the allocation of parental rights, custody, visitation, those types of things. I am not going to argue that. But what I am going to say is that the appellee fails to make the argument or fails to accept the fact that there's a difference between a civil marriage and having certain rights under the law. For example, if we bring it into our own backyard, we have people who come to our court every day. They're not married. They have a child. One party asks for custody. One party asks for child support. Certainly, the appellee is not suggesting that parties who are unmarried have the right, who have these rights to seek child support, et cetera, that somehow that raises their relationship to a valid civil marriage. I think that is the...
Can I ask you a question? So is it your contention then the only thing you're really contesting then is the divorce? Because if you're saying that as the civil marriage, they still have the right to support and child custody. So those two issues really aren't contested. Primarily, it would be the argument, your assignment of error as far as excessive attorney fees, and also, well, maybe some of that, I don't know, but also the complaint for legal separation or divorce. So
no, I didn't mean to cut you off.
I'm saying, would the court continue then, in your opinion, to have jurisdiction over child custody issues and child support?
And the answer to that question is in the negative, Your Honor, but if you want, I'll explain why. 3105-17A says that the domestic court has jurisdiction over divorce and legal separation if the parties, and I'm going to paraphrase, are married. So the core issue before Judge Boros was, did the court have jurisdiction? And the appellee was asserting that they were married and therefore the court had jurisdiction. We, on the other hand, said they were never married, so therefore the court did not have jurisdiction.
But would that also mean that, would that also mean that she would have to give up her H-4 visa and her permanent residency since they were never married?
Well, Your Honor, there's a difference between what the State Department says, and it never was really clear what the guidelines were for the State Department to determine whether or not they were married under those regulations. There was no testimony other than Mr. Brown who was called by the appellee, made some arguments about typically these things, these visas are granted. We have no idea. The evidence is unclear as to what the State Department took into consideration to issue a visa. It's interesting that I believe Judge Burroughs issued an order for the parties to obtain the immigration file. Never appeared. It would never appeared. So it seems to me, to answer your question, that we don't know the standard. Maybe the standard for the State Department to issue a visa recognizes a Muslim rights ceremony. That may be true. I don't know. But that's not the standard here in Ohio. And I think that's the distinction we're trying to draw. Now, Appellee wants to make that argument. See, the State Department, immigration, wants to issue this visa. Well, I'm not sure what relevance that has to the core issue. The core issue is, were the parties married under South African law? Our court, in the Mollagee case, said that to determine that issue, the issue of whether they're married, you have to go to the country where that marriage ceremony was performed. And Mollagee says that if the marriage ceremony, and I'm going to paraphrase, was performed properly, then Ohio will recognize that marriage as being a proper, valid marriage. But Mollagee also says that if the marriage was not performed in accordance with the law of whatever country where the marriage took place, then Ohio does not recognize it. And the cases we've cited, in fact, I did not find one case where a court in Ohio did not follow that theory and found where a marriage was improperly executed, that there was no marriage. This
Counsel,
case,
let me ask you a question. And
Sure.
I think you're talking about Mazzolini, if it's valid
Yes.
in one state, one country. But that rule, when you cite that line, it specifically says generally, not absolutely. And, an exception could be if it's against public policy in another area. For instance, if a father and daughter got legally married somewhere, that's a pretty good example of something that might be against public policy. So it's not an absolute rule. Would you agree with that?
I don't know that I would agree 100% with that, but I'd like to respond to that in two ways, if I may.
Well, I want to throw in another wrench before you respond.
Okay.
Hold your thought.
That's okay.
Since those cases that Judge Burroughs relied on, I'm pretty sure it's been since then, I think 2018, because the court gave the president, and I apologize that I'm not familiar with the South African government, but it gave him 2 years to basically do something about the Marriage Act that you're referring to. I think, a women's advocacy group brought the case and actually found in their favor. We're coming up on that 2 years, if I'm right. Maybe next week is going to be the deadline. And that ruling specifically said that by requiring the Muslim religious marriage to fall under the Marriage Act and be civilly registered, it was discriminatory and against their constitution. Is that a public policy issue that would, not make it have to be followed here? I didn't word that very well, but I think you're following.
I did follow you. So I'd like to answer that.
Please.
First of all, we have no evidence to indicate that the case that Judge Burroughs relied on was ever affirmed. I'm not exactly sure if the right word is affirmed or overturned, because I'm not, I don't practice in South Africa. But I think that's, so no one has ever said to the court, number one, that this is, quote, the law of South Africa. We have within Ohio 88 counties, and we have something like, 12 judicial districts. Just because a case in the 10th says X, Y, and Z doesn't mean that the 9th has to follow it. So I'm not sure I agree with the statement that you made about that particular case and its impact. What I would say to you is this. When we tried this case before Judge Burroughs, that was the facts that she had to rely on, not what may happen in the future. And what is important is that when we tried this case to Judge Burroughs in November, the Marriage Act of South Africa, number one, said that you could not have or would not recognize a Muslim rite ceremony. That's the first thing. And it said that the only way people in South Africa can get married is if they participate in a civil ceremony under the Marriage Act. So it seems to me, to answer your question, that number one, this one case that the judge cited, nobody knows the outcome of it. Number two, there's been no evidence to indicate that the Marriage Act has ever been changed. So it seems to me, to answer your particular question, is it discriminatory? I'm not sure I would agree with you, because are we looking at it in the sense of discriminatory under the eyes of an Ohio court? Or are we supposed to do it under the, I say Mazzolini, I'm not sure if I'm saying it right. I hope everybody knows what I'm talking about. Or do we look at that situation in the eyes of the South African courts? It seems to me that that's what we're supposed to do. But I'd also like to answer your question about public policy.
All right, go ahead, wind that up, because you're into your rebuttal time. I paused it to answer my question, and I'll extend yours also, Mr. Rich, to be fair. Go ahead, answer the question.
You know, the issue of public policy is a very difficult question, but I'll answer it this way. Is it against public policy to recognize to give weight, standing to religious marriage that never was in accordance with civil law? Is that the public policy that we should be talking about? Because it seems to me that if you take the, so to speak, the argument that you've addressed, Judge, I think you actually are going against public policy, because I believe that the public policy in Ohio is to recognize valid marriages, not marriages. And so,
okay. With that, you're in your rebuttal time. You can keep going, or you have about 2 minutes and 12 seconds left. It's up to you.
Right, Your Honor, I think I'm going to hold my 2 minutes and 12 seconds until Mr. Rich finishes.
All right.
Thank you.
Mr. Rich.
Thank you, Your Honors. My name is Jonathan Rich, and I tried this case on behalf of the appellee with my colleague Christopher Reynolds. Your Honors, this case is about a 4-year-old child who was taken from her father, about a 6-year-old child now who was taken from her father 4 years ago and is yet to return to the state of Ohio. Not even for one visit has she returned to the state of Ohio. In 2016, Judge Burroughs found that the wife's conduct in leaving with the minor child to South Africa in an effort to secure what she was advised exclusive rights to the party's child is reprehensible and inconsistent with Ohio public policy and the Hague Convention. Sad truth, Your Honors, is that the wife took the party's child thousands of miles away from her father and refused to bring her back, all because she believed, based on incorrect legal advice, that she was not married. She has used this as an excuse to keep the child away from her father. It has never been alleged that the father was anything but an integral part of the family. The parties lived together. The parties had a child together. The child was in the home with the father at the time she left. That has never been in question. This whole argument regarding the validity of the marriage has been prosecuted by the wife so she can retain the party's child in South Africa. The 1980 Hague Convention on the Civil Aspects of International Child Abduction provides that the parent must have rights of custody at the time the child was wrongfully removed or wrongfully retained from their place of habitual residence. If the parties were not married at the time the wife refused to return the child to Ohio, then the husband would have a much more difficult time proving in his Hague case that the father had rights of custody and in turn had the right to have the child returned to Ohio. Under 3109.042 of the Ohio Revised Code, unmarried fathers lack parental rights until an order is granted by the court stating otherwise. This is the reason that the wife is fighting so hard to claim that the parties are unmarried, because if the parties are unmarried, father would have to go to court to have any parental rights, and therefore under the Hague Convention, he may not be entitled to return of the child to Ohio. The standard of review for this court is an abuse of discretion standard. The trial court unquestionably had subject matter jurisdiction to decide if the parties were married. This is what divorce courts do. I don't think that's even in contention by the appellant in this case. The issue before the trial court was whether or not the parties were married under Ohio law. This issue required a factual inquiry. The trial court had a trial. Judge Boros heard testimony from the parties and multiple expert witnesses, including 2 expert witnesses on the law in South Africa. And Judge Boros made a determination that the parties were indeed married. The trial court had to assess the credibility of the expert witnesses, rely upon their curriculum vitae and their experience, and then make a judgment. And the court heard competent, credible evidence upon which it relied in finding that the parties were married, and that decision should not be disturbed by this court. A civil marriage is not the only type of marriage recognized under South African law. This is not a strange concept, or it should not be a strange concept to us. We still have common law in the state of Ohio. We still have common law marriages, although they have to be formed before October 10th of 1991. We, as a state, still recognize common law marriages. We also have the traditional marriages that we think about, where a party has a marriage or obtains a marriage license before marrying. In South Africa, the law provides for various rights to couples married under civil law, religious law, and customary law for Aboriginal people. The question for the trial court had nothing to do with whether or not the parties were married under the civil law of South Africa. The legal question before the court was, is the party's Muslim marriage void under South African law? In other words, did that Muslim marriage have no legal effect whatsoever under South African law? Was it barred under South African law? In fact, the wife could point to no statute in South Africa that would make the marriage void. That's because there are numerous statutes, they call them acts there, numerous statutes that give rights to parties married under a Muslim marriage. In fact, I think my opposing counsel just stated so in his argument. Nor could the wife in this matter show that the marriage violated public policy in South Africa. Rather, the evidence at trial was that numerous statutes and case law provided rights to spouses of a Muslim marriage. In fact, both experts on South African family law testified, and we quoted in our brief, that Muslim marriages, in fact, have legal effect in South Africa. In other words, there are legal rights that flow to Muslim marriages in South Africa, not under Muslim law. This is under the state law in South Africa, under civil law in South Africa. Rights of inheritance, pension rights, spousal support, parental rights, privilege against testifying against your spouse, even under recent case law, divorces are rights of spouses in Muslim marriages in South Africa. Consequently, a Muslim marriage is not merely ceremonial, as my opposing counsel stated. It's not only a ceremony. In fact, it was actually a certificate granted by the presiding authority in South Africa. It has legal effect. It's not just a ceremony that the parties entered into. It's kind of like our common law marriage. It's not just ceremonial that you stood under the stars and declared yourself married under common law. It actually has legal effect, and therefore it's not against public policy or barred by some statute. Consequently, the marriage in South Africa is not void. Now, the wife in her brief constantly uses the term valid. What is a valid marriage in Ohio? A valid marriage is a marriage that is not void. Void would mean the marriage is contrary to a specific statute or against public policy. For example, two parties that are, for one of the example used by the court was, somebody marries their daughter. Yes, that is specifically against Ohio Revised Code 3101.01, 3101.01, which defines who may marry. So that example that the court gave is void because it specifically states that parties, I think not closer in relationship to like second cousins cannot marry. So that's specifically void because there's a statute that says it's void. Such marriages, otherwise, such marriages are only voidables. For instance, in some of the cases that are commonly cited, such as Dodrell, the officiating person was not licensed by the state to officiate at the wedding. In Cecchini, the officiating person was not authorized to marry the parties in another county. These people didn't get married. These are cases, though, where the courts have said those marriages are not void. We are not going to find that those people did not get married. We are going to uphold their marriages because they are not void. The policy of Ohio is to encourage marriage. It is not to remove a parent from fatherhood from his 6-year-old child, which is what the wife in this case is asking the court to do. Basically, obliterate this father's status as this child's father. Is what's being requested here. Because if the parties aren't married, he has no parental rights whatsoever.
Mr. Rich,
yes.
I'm sorry to interrupt you. Can I ask a quick question? I thought I heard
Absolutely.
Mr. Gottfried say that Judge Boros ordered that the State Department's record be presented in this case and that they were not presented. Is that true?
So there was in part, it's true. There were immigration records that were presented at trial. In fact, we had an expert witness testify about the laws regarding immigration. The parties had a number of documents from their own records regarding their immigration submittals, visas, requests for green cards, all of that from their own files. In fact, the federal government never responded to a subpoena, and they responded that they don't have to. So yes, the official file is not produced, but we had an expert witness testify regarding immigration law, and the parties had their own documents. And for that, in that testimony, both parties admitted that when the State Department requested some additional information regarding their marriage, what they submitted was a certificate from the Muslim Authority in South Africa. That's what they submitted. So there was testimony in the record. They had an inquiry. They sent back. They requested the certificate from South Africa, the Muslim Authority in South Africa, and then the parties themselves submitted that to the Immigration Authority. And then after that, the green cards came. So they never hid their status. This was disclosed to the federal government. It was, even the wife testified she thought she was married under the Muslim rights marriage. That's why they filed tax returns together as married. She had health insurance here because they were married. They bought a house, joint survivorship under both names. And in the form, she said she was married. So it was never a question that they were married. What she has tried to do is say that Muslim rights marriages have no legal effect, but that's not the case law in South Africa. There's no statute in South Africa that says the Muslim rights marriages are illegal, as in some of the cases where we have orders. In one of the cases, taxing was a Cameroon. They had a court order where the parties had litigated in Cameroon, and the court said this is not a marriage. Okay, well then it's void because the court over there said there's no marriage. But here we don't have that. And there's another case where there's a South African law that says you can only get married this way. We don't have that in South Africa, just like we don't have that in Ohio. It's no different. This is not a void marriage. That is the question. Was this marriage void in South Africa? And if not, is it now void here in Ohio because of some public policy in Ohio that would say it should not be recognized? And the answer is no. We recognize marriages in Ohio where people mess up. They don't follow the rules to get married. And we still say, you know what? Our policy in Ohio is we strongly believe in marriage. We're not going to void your marriage because you didn't do some paperwork, right? Or you didn't have your officiating person licensed in the county. We're going to recognize your marriage, despite not strict compliance with the statute that says how do you get married. So the parties never represented that they didn't have that they had a civil marriage. We're not arguing that. We're arguing they have a valid Muslim marriage. That marriage as testified to by the various experts in this case, has significant legal impact in South Africa. It's not just they got married before a imam and that was it. There are legal rights under state law in South Africa for those type of marriages.
But
And this court should recognize that type of marriage.
There are those legal rights, and Judge Boros cited some cases, and there have been cases since then. But isn't it true that South Africa still, I'm going to use the word valid again, still doesn't recognize a ceremonial marriage performed by an imam who hasn't been certified, and I'm assuming because of the year that your two clients were married, the imam was not certified. They still don't recognize it as a marriage.
I don't agree. First of all, you used the word valid, Your Honor. What does that mean? Does it mean it's not a civil marriage? I would agree. It's not a civil marriage. It is a valid Muslim marriage. It is not void. It is not without significant legal effect. And that is the question. It's not whether or not it's a civil marriage or a valid civil marriage. Is it a Muslim marriage that has legal effect? We're getting confused over the terms valid and void, but I think very strongly in our case law here in Ohio, the question is it void? Is it without any legal effect? It's not whether or not it's civil or is it Muslim. Is it without legal effect? Because there's a statute that says it's without legal effect, and there are many, many statutes that give it legal effect in South Africa, okay? There are a number of statutes that give it legal effect and numerous precedent case law that give it legal effect. So it is a valid marriage. Is it different from a civil marriage? It could be different than a civil marriage, but it is not invalid or void, which is the real question here before this court. So we would ask this court to affirm the trial court's decision and uphold this marriage and my client's fatherhood. Thank you.
All right, thank you.
Thank you, Your Honor.
All right, you can go ahead.
Thank you. First of all, I want to respond to this issue about the Hague Convention. I've heard this argument throughout the trial. It is not an issue for this court. There was a separate proceeding in South Africa that dealt with this issue. It has no bearing on this case. Number two, counsel misstated, I'm assuming unintentionally, the law in Ohio. He said that if the parties, if Ohio, we have to look to see are the parties married under Ohio law. That is absolutely incorrect. We've talked about the Mazzolini case. It is clear that you look to whether or not the marriage in South Africa rose to the level of a civil marriage. I want to comment on something that counsel said that I found interesting and we raised in our brief. He argues that the Muslim rights ceremony has legal effect and the imam created it, this religious ceremony. We know that it didn't come from the civil law, so it came from the religious law. No dispute about that. So here's my question to the court and to counsel. If in fact, counsel takes the position that this marriage was created under religious law, then shouldn't the same religious law be able to grant a divorce? We raised in our case the issue of the fakash. The court in its findings of fact, I believe it's number 22, acknowledges that. There's testimony. A fakash is the Muslim equivalent of a divorce. It is the same as a get in the Jewish religion.
Well, it's not exactly the Muslim equivalent of a divorce. It's more of an annulment, correct?
You know, Your Honor, there was back and forth. I'm not sure that it clear. I don't know that it cleanly translates, but my point that I'm trying to make is it terminates the relationship. So if you follow counsel's argument, then by the time we got to court, these parties were no longer married.
Counsel, with that, your time is up. If you want to do a conclusion sentence, go ahead.
Thank you very much.
Good luck with that.
Yeah, right. Your Honor, we'd ask the court to reverse the trial court's decision on that basis. We'd ask the court to also grant find that the award of attorney fees was not appropriate. And we've also addressed the issue of the court's conduct in modifying unilaterally the shared parenting plan. Thank you very much for your time. I appreciate it.
All right. Thank you both very much for your arguments and your briefs. We'll take the matter under advisement, issue our written decision in due course. It will be mailed to both sides as well as posted on our website and that of the Supreme Court of Ohio. The next video